All right, it's a little after 2 o'clock. I'm going to go ahead and start today's training. Thank you all for being here. I see some of us trickling in to the call, and very happy to see so many of you join us for today's training session. I think it's really important to go ahead and learn about some of the things that are causing complaints in the legal arena in real estate. And what I mean by that is I think that it's important to cover issues that cause transactions a lot of liability, responsibility towards the seller, towards the buyer, as well as towards the brokerage and the agent. And I think it'll be a great time for us to cover some of the common issues that we see in transactions and what things as a broker we should or should not be doing in terms of guidance, consultations to our clients. Anybody have any questions or situations that you have that you guys want to cover? If not, I'm going to go ahead and start screen sharing a couple of things that I wanted to pull forward. And inside the Dynasty Agent Resources, I've uploaded quite a bit of attorney comments that you can see right here, which are written by an attorney in terms of things to watch out for, things that are kind of commonly causing trouble in other agents' transactions in the past. And I take it, I believe it's very worthwhile to kind of see what are some things that we should have reminders on, a refresher on, and hopefully you guys can unmute yourselves and ask questions because this opportunity and this time is for you. So make use of it, collaborate and talk. In terms of what I've seen from an attorney's perspective, here's going to be a kind of list of items that we can kind of cover and discuss. And I'll give you my 2 cents as a broker and my experience, how to resolve and how to overcome some of these common questions that our clients are going to ask us. So we're starting here on 1031 exchanges. 1031 exchanges are a great tool from an investor perspective to kind of defer the payment of your taxes when you sell one of your income properties. And then what the government and the IRS allow you to do is to purchase a replacement investment property. And there's specific rules on there. What this does is if you have any gains and you sell a property, everyone knows that when you sell a property, you always have to pay taxes. There's 3 things in life that are for sure. You know, there's death. There's, what was the other thing? Death, something else, and taxes. And I'm just telling you, there's no way to avoid it, but there are some tools to postpone it. And that's a 1031 exchange. So the important thing to remember, this must be a income property. And a lot of questions that I always ask me is, yeah, this is an income property, but then they did not report it as an income property and on their tax return for the past couple of years. Maybe they did unreported income. Maybe they leased it out to a family member and they're not reporting that income. Well, guess what? You're not going to be able to take advantage of the 1031 exchange when it's not listed as an income property as reportable income or loss. Okay, so that's one easy clarification is you cannot do that 1031 exchange unless it's a real income property. And when you do an exchange, it does not have to be the same type of property. I can sell one single family residence that I've been renting out for 5 years, and I can exchange that property since I've gained some value into a 3-unit triplex. Okay, I can exchange it into a retail commercial building, and I can do an office space and rent that out. So it does not have to be the same type of asset, but it must be a rental or income property to another income property. All right, so that's one easy clarification tool. And there's timelines that are very, very strict and important that the IRS gives you if you want to take advantage of the 1031 exchange. And you cannot budge. You cannot say, oh, but I have this reason or COVID or this and this. There's no excuses. You have to follow the exchange rules. And there's different types of ways you can structure a 1031 exchange, but the most common and the easiest and simplest way is to do the identification way style method of doing the 1031 exchange. So what you normally do in a typical situation is when you sell an income property, it has a close of escrow date. And the proceeds of the sale, let's say I have $200,000 of gains that normally would be considered as capital gains, I would actually transfer from the escrow officer the proceeds into what's called an accommodator, 1031 tax exchange accommodator. And they will hold the proceeds for the seller's behalf as a neutral third party. When you go ahead and follow the rules of the replacement property, which is the exchange property, all you have to do is simply identify.
Kelvin.
Yeah.
Kelvin.
Hi, Jean.
Yeah, this is Jean. Yeah, regarding the 1031, you just talking about like the earning proceed. So like example, if my client sell the property like 600,000, okay. So when he bought it back and it's like 500K, he make 100K, right? And then so when she do the 1031 exchange, the property value, if she buy for herself to live, so what kind of the price my client have to looking for that? Is 700,000 or she can bought it like 500K?
Yeah, it needs to be equal or greater. If you're going to do less, then you can do a partial exchange.
Okay.
Okay, but you just already just told me that it's something that's not going to qualify. You cannot sell a rental property and then you buy a primary residence, because in order for this to be qualified as a 1031 exchange, it needs to be a rental property or income property. So you disqualified yourself if you're going to buy a primary residence. That's what I just explained in the very beginning. Income property is
like
to be an income
right
property.
now, I just have a client talk to me this morning. Yeah, your topic today is very good, and she want to sell her own house and plus the investment property because she need to looking for the biggest one. So you need to sell one. How to say that? She need to sell one income property plus her own straight onto Central Avenue. Own property, her own property, and
So
then combine these two and to looking for the biggest house. So that means have total 3 escrow, right?
So she's selling two properties.
Buy a house.
She's selling two properties.
So can on the paper she have to write down like 1031.
That's a very complicated situation.
Kelvin, I cannot hear you.
Can you guys hear me right now?
Kelvin,
Jean,
I cannot hear you. Yeah.
Okay. So
yeah, right now, yes.
You have a complicated situation, and you cannot mix and match. This is a 1031 exchange is a rental property to a rental property type of situation. So your primary residence, if there's a client that's selling the primary residence, that's not going to be involved because that has been declared on their tax returns as a primary residence. So you're not going to take anything like that. When you sell your primary residence, you're going to pay your normal capital gains tax, or you can get that excluded using the 2 out of the last 5 years rule. And that's going to help you. Why defer the taxes using your primary residence? You should just take advantage of the capital gains exclusion
Right.
that you lived in there for the 2 out of the last 5 years. So then there's no point in deferring it. Just get the exclusion. So now then you're only talking about the one other rental property. And so with the other rental property that they are trying to other sell, that can qualify for a 1031 exchange, and you can exchange it to something that's equal or greater, and then just use that as itself. But then if you're going to buy something that's going to be a primary residence, then that 1031 exchange doesn't qualify. Okay, so your client should talk to a 1031 exchange accommodator. I have 2 people that I can refer to you that will explain to you your clients in detail, but you cannot double dip in tax advantages like this. The only way I can say you could double dip is if you had a property that was a primary residence 2 out of the last 5 years. So for example, 2016 and 2017, and then 2018, 19, 20, you're renting it out, then you can take advantage of one or the other, something like that. But I'm not a tax consultant. You're not a tax consultant. So you always defer the client to speak to a tax professional or an accommodator who can help them out with this. Okay? Don't give answers.
So if we use Connie, so is Connie have the accommodator and work together with her?
Yeah, she has several that many that we've worked with, but there's really nothing to work with. It's between the client and the accommodator.
Okay.
Escrow will send the proceeds to the accommodator when you send them a signed 1031 exchange agreement.
So I can ask Connie for the accommodator's phone number, right?
Yeah, there's many out there, but yes, she has some that are very reputable.
Okay.
Okay,
thank you.
That's a good question. Sorry, I cannot ask that. I can't answer that detail because it sounds like they're trying to do double dipping on something, and that's not going to be technically allowed from the IRS.
Yeah, no problem. That's normal.
Okay.
Okay, good. Thank you, Kelvin. Appreciate.
Now, the other question or the other thing to talk about is I told you there's identification period. You have 45 days to identify up to 3 properties that you might potentially exchange into. And these just have to be the property address. You don't have to have closed escrow by then. You have to close the escrow by 180 days, and that's strict. 180 days prior from the date of your closing. And it is possible to do a reverse 1031 exchange, just so you guys know. And that can also be done where you purchase a property first, use that as a rental, and then go ahead and sell your exchange property that you already owned. And that's going to be you could also do it reversed as well. So that's something you can talk to the exchange accommodator for the details, because everything has fine print that you need to read, and have the person who does this on a day-to-day basis explain it to your client. You don't need to explain anything. You just have them send them some links to some articles and send them a couple of references that they can speak to, and always defer them to their accountant to get them on board with the way it is you're trying to structure it. Okay. Now, number 2, you guys can see here on my screen, there's been a lot of confusion about COVID-19 and the rules about what we can do during this type of, what would you call it? During this type of crisis and this pandemic. So when we follow every broker has different rules and procedures that needs to be done. But for us as a brokerage at Coldwell Banker Dynasty, I put together the brokerage prevention plan. And that is all the rules that you need to be following when you're selling or buying or helping your clients in real estate. We are an essential business according to LA County. And as long as we do and practice the measures of social distancing, no open houses, we're disinfecting the homes between showings, everything is done by appointment only. We're making and ensuring the utmost safety by asking for all visitors to send a PED visitor form to you as a listing agent. And we have even doing above and beyond, which is having available gloves, sanitation wipes, and face masks available, making sure that every person is entering the building is doing the best that they can. You're even supposed to read the PV form, which says some of the rules that you're supposed to be doing. Some simple things like opening the windows for so that the air could kind of air out some of the air. You're also going to be doing other things like disposing things in a sealable trash can, disposable trash can. When you exit, you're not recycling or reusing any of these same materials that we're using, like gloves and shoe covers. And ultimately, we're going to try to make sure that the clients are not touching surfaces unnecessarily. In fact, I just recommend you as the agent who's showing the property to wear gloves and open the doors for them, turn on the light switches for them, arrive early, and just make sure that you disinfect after you leave. Okay, so that's kind of a simple rules that we all understand, but I just want to send that reminder. And going to the next attorney recommendations for agent brokers, ultimately, there's a lot of issues going on right now regarding financing. Yes, the interest rates are amazing. They're under 3% or less for a well-qualified borrower for a 30-year loan. And oftentimes, we're going to come and approach some situations where the seller wants to sell a property, the buyer wants to buy the property. However, maybe for some reason they cannot obtain the financing. Okay. In certain situations, this could be when the buyer, maybe they don't have enough reported income on their tax returns, or the job income that's verified is insufficient. Maybe you have a situation where the property doesn't qualify for a loan. Maybe there's been too many insurance claims. Maybe there's been a situation where there's big illegal or unconverted areas, like a converted garage, or they added a lot of square footage and this does not appraise, nor does it get the, it's too many issues with the property that requires a correction from city violations. And so these are all the reasonable ways a lender can deny a loan for financing because the property doesn't qualify. Another reason why it doesn't qualify is not habitable. Maybe the heater is not working. Maybe it requires major renovations and the lender is too fearful or conservative. They don't want a loan on this product because it's not habitable at the current time. And the seller does not have the money to fix it during the escrow period. Anyway, regardless of which, whether the person doesn't qualify for financing or whether the property doesn't qualify for financing, one solution could be a seller carryback. But this is a very cautious solution as a brokerage. When we use this as an option, we need to clearly explain to both the buyer and the seller the correct language and the correct precautionary things to consider, because obviously this is when the situation is when the seller becomes the lender. And so obviously this is where the seller is, if they're going to do a carryback and the seller is going to be assuming the loan and giving the buyer a loan, the seller needs to understand that all the rules and recording the deed against the property, taking first position, signing proper documentation, and probably getting legal attorney advice whether or not they should proceed in this, because as agents we can help them with the forms, but it's up to them and maybe their attorney to go through whether this makes sense for them and if the language is good enough for them. So when you have a situation like it doesn't appraise and the buyer doesn't have enough down payment or they're not able to get the financing, when you read this, it is possible as a solution where you could propose a seller carryback. And this is typically a situation that you need to be clear on. One typically is you cannot have a carryback when there's a loan in place. Typically the traditional banks don't want to have a second lien on the property at all. So if you're going to do financing and you're trying to close the gap from an appraisal for the difference, that's probably not going to work. Okay, with most traditional lenders, you could talk to your lender, see if they will be open to it or not, because every bank runs and operates differently, and they all have different risk tolerances. Some would suggest that you would, hey, well, why don't you just do a second trust deed with the seller, but don't record it yet, okay? And that's like a fraud. Even though that would work, that is not something that we can give guidance or allow, because the bank is a federal loan. They're providing the money to the client. And when you just record a second trust deed silently after close of escrow, that is very, very dangerous for that seller and buyer. When you add this lien in after close of escrow, it's really not good practice. You might get involved in some complaints, and it's something that we don't want to be involved with at all. So I don't condone this type of solution, even though some sneaky buyers and sellers try to make it work. Okay, so there's a lot of different ways to handle this. You know, if you're having a weird situation like this, let me get involved or let me know about it so we can try to advise the client with the proper instructions. Okay, any questions on that? If not, I'll go to the next kind of commentary. And so this will be nice and good stuff. This was from April 2020. Wait, this was the same one. So one thing that we've seen in common practice in going on in real estate is that we see that commercial and apartment businesses for a buyer agent, we've seen many situations where the buyer or investor in commercial real estate tries to tie up a property, puts it and opens up an escrow, they put it in deposit, and they put in a long due diligence period and a long escrow period. And it does happen in residential as well, but it's most likely in commercial. And what they're trying to do, and I've seen this myself in our own transactions, is they're trying to assign this property to another buyer, investor, and trying to do a double escrow and or trying to profit from selling the contract. Is this legal? It is legal to assign a property, and it is legal if you're going to assign it, if you're going to take a profit, as long as you disclose that you're taking, selling it for profit. But when you're doing this type of double escrow, there is a lot of things to be wary of, and you should always try to sense and get a picture of what's going on. So number one, why are buyers tying up these properties and trying to, do some sneaky stuff on the side? For one thing, sometimes they might have really high cash balances, and so they try to tie up the property in order to delete competition. So you get into escrow, you negotiate something quickly, you show them you're a cash buyer, and then later on mid-escrow, you try to renegotiate a better price or terms. So you'll see this very common with investors or very savvy, sophisticated, and experienced investors will tie up a property, do some due diligence, and later on renegotiate that price and ask for a $50,000 price reduction. Sure, that might happen. It happens. And are they allowed to do that? Yes, it's all negotiations. It's in the contract. You could renegotiate or cancel. So number B, they say, well, sometimes they do this. They're looking to double escrow this and look for another buyer to take over what's called the assignment, to take over the contract of sale. And typically when they do this, they try to make a quick $20, $30, $40, $50,000 because they probably secured the escrow at a very attractive low price. Sometimes I've seen this in our own escrows, where I've seen a buyer who pretended to be a cash buyer, and then they put the listing. They took the property and advertised it in their own website. They advertised it to their investors email group, and they have 500 people on an investment group email forum, and they try to sell it to another person, and for a quick $20,000, $30,000, $50,000. Okay. I've seen them advertise it on Craigslist too. Okay. There's a lot of people out there that are trying to do stuff like this. So be cautious, when you have situations like this, and you'll know when it's fishy when you're not getting a lot of responses, and or you see advertisements of your listing elsewhere. And sometimes I found out about this when a buyer called our company and saying, hey, I see your advertisement for the listing. It shows pending. However, this website shows it's active. And then I find out, and I do some discovery, and I find out that they're trying to double escrow this transaction. Other times, and they try to do the due diligence and tie up the property, they put a long diligence period because they're trying to say that they're going to improve the property or get permits or do some architect designs and work with the city, and that's the reasons for delaying the escrow. So if you see these signals, then be very wary when you try to you're not getting the action or performance from the client. Okay, so you should keep them on a very strict contingency period timeline, and be very communicative and follow up with them with what's going on. So here are some things you can do in the residential area to try to see whether or not this is a sneaky, sophisticated investor who's doing this stuff, or if this is a true, honest, sincere buyer. Here are some solutions. You can always just ask for a larger deposit. Typically, the sincere buyers will be putting a larger deposit, closer to 3%. Okay. You can ask for the buyers to provide their financials and review them during your counteroffer phase prior to signing a contract. Make sure you get to see their proof of funds, their pre-approval letter. Make sure maybe you have a discussion with the lender and see if everything is making sense and matching, and there's not any discrepancies in what they're saying. You would like to see a bank approval, not just a pre-qual or not just a simple pre-approval. Hopefully you can get something that's a DU approved. So before you sign the contract, you would like to see that they have the closing funds that they declare they have, okay? And if you see any red flags or solutions, talk to your broker manager. Another issue in many escrows that I've seen fall apart, we've had one as well last year, where there is a shared driveway between a home and maybe 2 or 3 neighboring homes in the rear. Maybe there are flag lots. And this happens when there's maybe a home or a business in the front, or there's a flag lot and a shared driveway going to 2, 3, 4, 5 other homes in the rear, because there was a subdivision recorded a long time ago. And this project was approved as a subdivision because there's a shared driveway. The problem occurs that when there is one or many other parties or homeowners that are abusing the easement, then it goes to a situation of neighboring disputes. So they could be parking on this easement and blocking the ingress and egress. Sometimes they leave trash or other obstacles on there. Maybe they put a basketball court, or they have a boat or RV parked and blocking it. And they're not properly giving access because that easement is for everyone. So sometimes you have abuse on those situations. How do you resolve this? Well, I can tell you, you got to take a look at the language and see what it says. But typically, you'll need an attorney to find out and discover the easement or the right of way, the language, and to write a letter. Okay, maybe an attorney can help you negotiate what type of disagreement or dispute on the usage of the easement is, and you can send a letter of complaint to get that to stop. Other things you can always, it usually comes in a situation is when it becomes time to repair the driveway and do the asphalt or concrete, and you got to get all of the neighbors to pitch in. So hopefully you can have a situation where all the neighbors are friendly and willing to cooperate on a shared expense. But sometimes you're going to deal with situations where neighbors are not going to agree to pay for something, and they say, well, I don't use it that much, I don't even drive, I'm not going to pay for it. So that just because they don't drive does not excuse them from the payment or the liability responsibility. So you sometimes you're going to have to get attorneys to get involved when it becomes time to do repairs. The next kind of concern or issue we deal with is regarding beachside or coastal properties. Anytime you sell a property near the coast, there is something called a Coastal Commission of California that regulates any type of development, improvements, or major changes to a property. Okay, they do have what's called jurisdiction for X amount of miles from the coast. So if you sell a property near there, you do need to understand that they do have jurisdiction. You have to get and approve any of those types of improvements that you're trying to do, because they have specific setback rules. They have, like, for example, maybe you're on the Malibu cliff and you're at the bluffs where you're high up on a hill and you want to build out a swimming pool, or you want to build out a covered patio or a rear ADU. You can get city approval and you can get all that stuff done, but you also, if you are within jurisdiction of CCC, you got to get their approval too, okay? Because a lot of times there's erosion and the soil kind of just slips off and falls, and you get landslides or mudslides. A lot of times they require you to have a 40-foot setback when you're at a bluff, and you still have to keep the normal setbacks from the street. So when you're getting a new development project, the CCC also has jurisdiction over what can be built there as well. So make sure you check with the Coastal Commission anytime you're buying a seaside type of property. And oftentimes when you're on a coast as well, there might be some people trespassing or walking through your property in order to get to the beach. And because if you don't fence it off, or if you don't write private property, people who are trespassing over 20 years and you don't put up a sign or fence it off, guess what? That might become unrecorded encroachment that will legally be allowed. Okay, so you do need to try to be cautious on that, as well as know about environmental restrictions. Okay, any questions on this page of attorney comments? The next topic I want to talk about, I'm pulling it up right now. Hold on, I'm getting a slow internet connection for some reason. You guys can hear me okay, right?
Kelvin, we cannot. No.
Oh, you can't hear me?
No, we are not. Yeah, it's very, very bad.
Yeah, I don't know why I don't know whether it's my computer. So can you see the screen now? Joan?
Yes.
Okay.
And now it's okay. Mhm.
I'll try. I'll see what I can do. Another attorney or issue concern of buying properties is that
It's no good again.
do what again?
It's no good.
Oh, I see.
Mm.
Let me I'm not sure what I can do. I can either change computers. Do you hear me okay now? No.
No good.
Let me try to sign off real quickly. I'm gonna sign back in. I apologize, guys.
No problem.
All right, so what I'm doing now. Okay, let me see what I can do now.
That is good.
I'm using my phone right now, and I'll use this and talk about it. So, hopefully, you guys can hear me better now,
Yes.
and I'll go through the attorney comments regarding views. Now, when you buy a property, you're buying the land and obviously the ground space, airspace above you, and a lot of times you might see a situation where a neighbor builds maybe a second story, third story on their home. Maybe you might be dealing a situation where they have a very large tree that grows very, very high, and now after time, it blocks your views that you used to have. Okay, when you have a situation like this, especially sometimes you're dealing with an HOA. Okay, if there is an HOA, they do have control over the situation, and they go ahead and try to make a rules in the HOA regarding limits of trees and the height of how large they can grow. So this could be an enforceable type of thing if you're living in an HOA, if you get it approved or reviewed on the CCNRs. However, you might be in a situation where it's a neighbor who is a family and there's no jurisdiction on that. Well, them to build a second, third story, okay, then it's approved. You don't have control over that. You could write a petition against it, and I've seen that done in the city, in the village area of Santa Anita of Arcadia, and some neighbors will write a petition against the owner trying to build a second story, and they've been able to deny some projects because they gang up on the new project builder because it's going to impact the views. Okay, so you just always be cautious and concerned. Never make promises like, yes, absolutely, a two-story will be approved, because there's always the potential of neighbors or potential of complaints. And for trees, you can always trim the trees that are on your side of the property line. But when it and when it comes down to if it's growing too big, but all on the side of the fence, that's something that you're not going to be able to do anything with unless you get an attorney involved to write a letter. Okay. Speaking towards vendor contract, okay? A vendor contract is a third-party type of situation, and you should always look at all types of agreements and contracts, such as when you're dealing with a commercial or apartment building. A lot of times, the buyer may not, or the seller might not disclose every single type of vendor that's involved. If you're dealing with a commercial building or an apartment building, some common examples are the laundry machines, where they rent the laundry machine, and then they make some side income from points. Another one might be like a snack machine, or a type of vendor provides snacks and drinks. Another type of thing might simply just be like a long-term contract would be a lease agreement. A company that is promised to do the next 5 years of termite. Different types of vendors out there. Just be cautious and always ask questions. Talk and review the contracts, especially in commercial buildings, whenever there is something that is not making sense, or have and ask for a copy of the agreement so you can see when they expire, the terms of the contracts, because when you buy a property, you are buying all of the long-term contracts that are assigned along with it, okay? So you're buying the contracts of the property that it's already associated with. So it's important to review everything, and not all sellers remember or disclose everything. So you have to have a very scrutinized eye in looking and asking specific questions. When you sell a property that's tenant occupied, it's common to provide a tenant estoppel certificate that's the responsibility of the seller and listing agent. So what is an estoppel certificate? It is a written statement that is signed by the current tenant when you're selling a property. And that buyer should be able to review the estoppel certificate to ensure and double check and verify what is the rental arrangement, the agreement of what's paid monthly, what is the rent and the rights and the usage of the property. And they should be able to confirm the security deposit being held and the specific, any special terms like who's paying utilities or the. So this is a very good form for you, whether you're a buyer's agent or a seller's agent, to make sure there's a estoppel certificate in place that's been verified with the tenant. Make sure of what is the arrangement for this rental, because I would not buy a house or a rental income property without knowing what is the situation. Okay, so you could be stuck in a situation where the seller claims that rent is $5,000 per month, and then they find out that the tenant is only paying them $500 a month because the seller is giving them a credit of managing the property for $4,500. You know, there's stuff like that that happens that you don't even know. So double check, verify, and get a tenant estoppel certificate signed by the tenant. That is a very, very good practice. Any questions? You guys are hearing me okay, right? Right, Joan? Moving on to the next section I wanted to talk about is septic and sewer lines, because in real estate, I've noticed that we all assume that everything is hooked up to the sewer, but guess what? There are many, many homes out there, even in LA County, that are not hooked up to the sewer line. So you check and verify to make sure and see if there's a septic tank or a sump pump or some other type of situation that needs to be cleaned out every so often. Double check, ask these questions. Use the appropriate disclosure form and make sure the seller discloses this on the TDS and SPQ. I can tell you it's a major, major disaster when you have a situation where they fail to tell them there's a septic. The buyer buys the home, everything works fine for a couple of years, and then all of a sudden the septic tank becomes over full and it backflows. And then guess what? Everything that was backflows is basically all the crap, all the feces, all the urine, and anything else that's being held up in there suddenly just like a volcano comes up through all of your toilets and all your faucets and all of your drains and floods the house with a disaster. It's cost a tremendous amount to fix and repair and clean out, and you probably have to replace everything, including the flooring. So you never want to have a backflow like this. Typically, before it backflows, you will be able to have some sort of smell coming. If there's no sewer hookup and there's a septic, you do need to make sure that the buyer is advised they have to do regular services to do the clean out to make sure it's not over full. And also, you have to make sure and find out the age of the septic tank because they do not last forever. They will go bad after X amount of years. I think you change them out every, I don't know, every 3 years or so. You have to ask and look at the materials and the type of septic tank you have. Okay, so watch for this TDS, and you know, always double check and ask the neighbors too is one solution you can do. I had a property on Margarita Street in Alhambra that I sold. This had a septic tank, and the seller did disclose it, and we found out there was a septic tank, and I double checked with neighbors to see, this is weird. So it's good to know. It's very important. Triple nets is dealing with commercial properties, and typically a lot of times you're going to see this referenced in commercial leases. Whenever you do a commercial lease, the definition of a triple net is basically where the tenant is paying for all maintenance of the property and monthly expenses, including the maintenance of the repairs. They're paying for the property insurance. They're even paying the property tax along with the monthly rent to the landlord. So a triple net is the best type of lease for a landlord in commercial buildings because the tenant takes care of all maintenance, all property tax, all insurance, and if they don't, then you can go after them for their security deposit and the balance of the rent, and hopefully you have a guarantee on that. The duties of the landlord is very minimal at that point, and so it's great to put people in that situation. But when you're representing the tenant in this situation, you need to ask for specifics. Ask for a copy of all the type of anticipated expenses so the client understands what they're paying and not simply just the monthly rent, but they're also responsible for the rest. Okay? So whenever you have a triple net, make sure the client who's a commercial, probably business owner or a type of they're putting together a business, they should have an attorney that they can talk to and speak towards to review contracts and whether or not this is a good situation for them or not. Okay. When you terminate a lease, whether it's commercial or residential, double check the contracts. Okay, because prior to sending them any notices or having a discussion about terminating the lease, you want to find out what are the viable options and what if the tenant has any protections in their lease. A lot of times I've seen situations where landlords don't do that review, find out that there is a addendum that provides the tenant an option to renew and for X amount of years or X amount of payments. Okay. Before you cancel the lease, here's a few suggestions to really minimize damages and what are some of the things we can do when the tenant tries to cancel the lease prior to the end of the term. It sometimes happens, and it happens in today because of a lot of businesses that cannot survive during a pandemic. We've seen many commercial spaces go empty. They're filing bankruptcy. They're running out of PPP loan money for their small business, or they're just basically unable to make the obligations to pay. So here are some ways to resolve. One, the tenant could try to sublet the property. They could release it or assign this lease to another business or another type of a tenant that could take over the lease. And maybe it might be the same comparable rent, or maybe they rent it out for less and sublet half of the property. Depends on the type. So yeah, you do that as long as you get landlord consent, and as long as you fulfill the rest of the payment, you would basically mitigate the damages that you're owing. Okay, instead of, if it's a business like it's for example a gym, like a health gym, or like what's a LA Fitness, 24-hour fitness. Well, they can't use the space because that's an essential business. But maybe they can sublet it for meetings or event space or a private film shoot or something like that that's allowed by the city, and they can release it out to someone else and get some income and pay off the landlord for their monthly rent, as long as the landlord gets their consent. The other thing they can do is they can try to propose something to the landlord. And sometimes a landlord might understand, they might be reasonable, and they can terminate the lease with a certain amount of negotiated penalty. As long as you get it in writing and you get a termination and you come to an agreement, that's probably the best case scenario for these commercial spaces or business. There might be some valid reasons for the departure of the tenant. Maybe the valid reason was the pandemic. And yes, LA County was protecting evictions for a certain amount of time, but other valid reasons, I mean, it's very difficult. You have to read the lease agreement to see what is considered a valid reason. I can tell you, if most commercial leases, they have a clause in there called force majeure. And force majeure is a valid excuse, it's in there, that the pandemic has caused the tenant inability to open, inability to run this business, and that they could not then to review this. And that's something that you're going to have to point them in the right direction. Okay? Any questions you guys have? I'm going to move to, and this one, let me pull it up real quick. It closed. Escrows, every time you have a sale, you should always get a copy of your client's closing statement. And to me, I don't like surprises. So I ask earlier whether I represent the buyer or the seller for the escrow officer to provide my client an estimated closing statement. So that way they can see what kind of charges are being involved, what the lender is charging them, what the title is charging them, and what the escrow is charging them. Because I can tell you, I've seen so many times where the escrow will make a mistake. Maybe there's an extra zero somewhere, or maybe there's just accounting mistakes regarding the proration of date and HOA fees. I've seen many mistakes happen, and not all escrow officers double check their work. So that's why you want to ask for an estimated closing statement, so you have sufficient time prior to closing to review all the charges and whether they are valid. It also gives you the opportunity, time to negotiate some of the junk fees as well, if you want to, or your client wants to. Another nice little comment I have is the rent control. We all know that there are cities that have rent control, like LA City, but we all must understand that statewide rent control now applies as well. So depending on the type of investment the property is, whether it's state or city, whether it's single family or whether it's a multifamily, all California properties are under rent control, but there are exemptions, okay? Single family homes and condos are exempted as long as they are declared and they provide the proper form, our rent cap and just cause addendum. And as long as the property is not held in a corporation or a REIT or an LLC, they should be able to apply for the exemption. So that way they don't have these just cause eviction penalties that they have to give to the tenant. They also don't have a cap that they can charge for the rent. They can be market rent. So when you're dealing with these, make sure you're filling out the box on the RCJC form page 2 and let your landlord understand statewide rent control and whether or not they are exempt or not. If the property is built within the last 15 years, it's also exempt, but it's not automatically exempt. You must provide the RCJC form with the proper exemption disclosure to the tenant. Okay? What I'd like to point out is that when you don't fail to give them the RCJC form, and if you fail to let them know that it's exempted, then the tenant can automatically assume this property belongs to statewide rent control. And then if you ask them to evict them and you have give them, you know, just cause or I mean, if they have no fault eviction, you're going to have to give them 1 month's rent, even if it's not in the rent control area. So all I want you to do is take a look at the drive or point them to the statewide rent control language. Let them speak with their property manager so they understand what's going on. And then make sure that they're giving the proper disclosures whenever they sign a new lease or renew a new lease. Okay?
Hi, Kevin.
Yeah.
Question. Oh, the lease property, any single family also gives this form to the tenants?
Every rental agreement,
Oh.
whether it's single family, okay, statewide rent control only applies to residential. Okay? So it doesn't apply to commercial buildings or offices.
Oh, okay.
But yes, every rental that you do, you should provide the RCJC form and let the seller declare whether they are exempt or not.
Okay. Kevin, regarding about the closing statement, I just mentioned one thing. Recently, I received one email from CRMLs, and they mentioned I did something, I mean, maybe something wrong with violence. I don't know what happened. They said they have to report the tax, on the tax, the purchasing price is different, a little bit different with my I close statement, the price with on the MLs I updated. So they asked me to send the closing statement. I don't know, this is my first time to happen this kind of thing. So
does the closing statement price match the MLS sales price?
Yeah, I match, but they have report. They said the tax on the tax the price is different, a little bit higher than my MLS price, closing price.
Did you put a tax on your property tax on your?
No, it's not me put. I don't know who put that one.
If MLS is sending you a request and you, I'll review it with you, but if you match the closing statement, you have nothing wrong. All you have to do is just cooperate. So you can send them a copy of the closing statement and say, yes, this is the proper price. We closed at this
I did.
That's what I reported. And you have nothing to worry about that.
Okay, yes, I did. And they said, yes, so far it's good. They didn't ask any requirements. Yeah, okay.
Good. Thank you for that question. Did someone else have a
Okay.
question?
Yes, Kelvin. Yeah, regarding one
Yeah.
of my clients' property in Azusa, which last time I talked to you, and because the tenant have COVID-19,
Yeah.
so right now my client need to have the professional go and clean it up, or the tenant can clean it up by themselves.
Are they continuing to lease the place? Or they?
Yeah, they will leave the place because we can lease as like the tenant still lives there, and then may attract some investor, and they when they purchase the property, and then they need to have as an investment property, and then they still have a income from the tenant. So what should I need to do if I lease the property? So as the current tenant still live there, so do the landlord, the current landlord need to do the professional COVID-19 people go and clean it up before we can show the property.
Well, I'm going to have to give you a couple of pieces of advice.
Uh-huh.
You told me the tenant is living there. Are they being quarantined in the house too? Or are they being quarantined at a hotel somewhere else?
The first time she was quarantined at the house, and after that, and then they sent her to the hospital. And
Yeah, but she's not going to live in the hospital just to be quarantined.
she have a quarantine 2 times. First time at home, after the second time test the go and take a test, still is positive. So they send her to the hospital. So she just get released week. So
And what is she going to do? Did she go back to her house or did she go somewhere
yeah,
else?
after she get out from her from the hospital, and then she go back stay in her house.
Okay. I'm going to have to tell you that when you put this listing on the market, you have to disclose in the private remarks to the agents that the occupant has been the occupant has tested positive for COVID-19. Listing agent does not recommend or does not want to allow any showings at the current time. The worst thing you want to do is get other people contracting the virus. That's not what we want. We don't want to expose anyone to the virus and be responsible for them contracting the virus because they touched the surface or breathe the same air as the occupant. So I would hold off all showings and ask the buyers to submit their offers subject to interior inspection later on. Okay, because I would probably sell this as a sight unseen, or ask them to if they are going to enter, you're going to have the buyers sign their own sign their own release of liability form, that they have knowledge that they know that the occupant has COVID-19 and they are still entering against broker's advice.
And do we have a standard form from the CAR?
Yeah, go to the sample letters and then you go to the buyer acting against broker advice, and you would have and write in there, listing agent has fully disclosed that the occupant has tested positive for COVID-19. Listing agent does not recommend any buyers or visitors to enter the property. Buyer and buyer's agent has been advised, and buyers acting against broker's advice. And entering at own risk, and buyer will hold the company, Co-Banking Dynasty, and Gene Chang hold harmless from any future liability or responsibility towards this disclosure and understanding.
I see. Okay. So
Good question.
yeah, thank you.
What-
So
what else did you-
in case can I recommend the current my client to do one time for the COVID-19 people clean it up, and after if the investor come over, maybe it's my same client from China, and to it will be better for the new investor or for my own client.
I mean, for
And
example, let's say the property is worth $500,000, right?
Yeah.
So if you wanted to do that, you could list this property at $440,000,
Mm-hmm.
do a professional full cleaning, wait 5 days from the occupant's last visit,
Uh-huh.
get a certified letter that it's been cleaned for COVID and fully disinfected,
Mm-hmm.
have 1 weekend of showings only, because if you have it under market value
Mm-hmm.
more than 10%, you'll get
Yeah.
a lot of activity.
I see.
And let all the buyers visit that 1 weekend, and you're going to shut off all offers by Tuesday.
Mm-hmm.
Submit your best final, and then don't let the tenant come back.
Uh-huh.
If you can accomplish all of that,
Uh-huh.
then I would say it's okay
Okay.
to sell the property. But where's the tenant going to go?
Mm-hmm.
Are you releasing them from the contract, or are they willing to terminate? Is the tenant cooperating? There's a lot of what if
Yeah.
scenarios.
Yes.
Okay, because even if you get it certified and cleaned, and then the tenant comes back the after Tuesday, the weekend, then
Uh-huh.
you're gonna have to get it disinfected all over
Yeah.
again, and you still have a possibility of new buyers contracting the virus, because maybe only the interior was cleaned out, but they might have touched the exterior door and contract the virus. I don't know. We don't know everything about the
Yes.
virus. So I don't know. To me, I would hope that the property is either vacant, or you do a blind investor offer purchase,
Mm-hmm.
or you wait, or you terminate the contract with the lease, the tenant, and you sell the
Understand.
property.
Okay. Got you. Very good suggestion. Appreciate.
But you would still have to disclose to every visitor, even after disinfecting, that they are coming in, entering at their own risk, and acting against your advice.
Yes.
I
Understand.
would still recommend that.
Okay. Thank you. Thank you, Kelvin.
Good questions. The last topic, unless you have any other questions before we conclude today, we're going to talk about holding title. And I'm just going to tell you that the agent or the broker is not responsible to tell the client how to hold their own vesting. Okay, we should share with them the differences, share with them the types of properties that they can do, but all of them, they have different tax implications, and disputes when there's a death, or disputes when there is one owner wants to sell and the other does not. So we should have them, select on their own the differences. The most common is obviously single or sole separate property, or a married couple as community property. The differences for tenants in common is when you have a percentage of a different percentage of ownership. So that's very good for investors who are in different proportionate shares. Maybe you have a 10% owner, a 20% owner, and a 50% owner, and another 20% owner. That could be done. Tenants in common percentage ownership based upon the amount they invested. One of the clear distinctions about a joint tenancy is that a joint tenancy has the right of survivorship. So that's equal ownership. If you have 4 buyers as joint tenants, all 4 are 25% owners, equally can use and occupy, or make decisions, and it goes to right of survivorship. Okay. Community property in California, if you live there for longer than 2 years, even if it's a property becomes community property, even if it was prior to marriage. Okay, there's certain legal things to understand. And we don't expect agents to understand all these differences. So you need to let them communicate and speak to the title rep or speak to their own attorney or tax accountant how to hold title. There are tax advantages and disadvantages if you want to hold title as an LLC or a corporation. The reason why most people put it under an LLC is if they're investors and trying to shield themselves from liability. And if there's 5 different homes that they own, and they put each 5 in a different LLC, the owner, not to be exposing the other 4 properties if someone trips, falls, and sues for $10 million. Okay, so that's a protection thing. Okay, but yes, you have to do your extra taxes and accounting, and it's complicated. So you want your client to understand that there's differences, as well as how the future taxes will be treated, because individuals get the benefit of capital gains exclusion on primary residence. And whenever you have a judgment or a lien, sometimes you might want to put it under an LLC or something like that, because you don't want to expose your personal liability or liens against you, or maybe you have a lawsuit. You don't want to lose everything else. Okay, so it's important to understand these differences. I mean, as a real estate agent, I expect you to know the differences, but you should be giving guidance on how. You should just giving them guidance, the differences, and give some links. Okay. Any questions about any of the topics that we covered today before we close today's meeting? I hope this training was very valuable to you. We covered many different topics. I still have many more topics to cover. Maybe we'll cover that next week. If you rejoin us, I thank you all. You guys are all the same students that come back week after week. I appreciate you willing and wanting to learn more. And I hope this is what you're seeking in our real estate training sections. But if you want specific topics, I ask you, please let me know what you want to focus on and learn.
Thank you very much, Kelvin. It's very great training class. That.
We cannot hear you.